Hello, Assalamualaikum. My name is Sarah Azahar and I was asked by Madam Namira to explain to you guys as to what is mooting. But before that, let me introduce myself. I am an alumni of Asasi Dengkil, where I was a student for 2 semesters back in 2016, and of course I did my foundation in law when I was a student there. And then upon completing my foundation, I enrolled at UiTM Shah Alam in the year of 2017, and recently I can finally say that I am finished with my journey in law school, and officially in August 2021. And at the time of recording this video, I am currently waiting for my final semester result to be released next month in September. Now, as for my involvement in mooting, I think I first started to moot back when I was in part 2 in degree, in which it was back in 2018. It was an internal moot competition called the Interpart Dean's Cup Challenge, where the team and I made it into final, and we were announced as the first runner-up for the competition. Then, as for my first external moot competition, the moot problem revolved around the subject matter of constitutional law. The competition was called the Tun Sufyan Constitutional Moot, and we were placed at the 3rd ranking for the competition. Moving forward in 2019, I participated in several competitions. The first competition was called the Pre-Moot, the William C. Viss International Commercial Arbitration Moot. This was my first international moot where I went against teams from India, Indonesia, and so on. Then in the same year, I participated in the Foreign Direct Investment International Arbitration Moot competition that was held at the National Seoul University in South Korea, and that the team and I, we were qualified to go to the global rounds that was conducted at the University of Miami in the United States of America. Joining such a competition has made me realize my love for this particular area, that I've decided to join it again last year, where I was awarded the Honorable Mentions Advocate ranking at the 9th place out of approximately 250 participants from all around the world. And our respondent memorial, we ranked the 2nd best respondent memorial, in which it was later published in the Transnational Dispute Management Journal. And I was also a recipient of the Manuela Beltran Award for the Best Woman Advocate of the Global South. And that competition marks the end of my mooting career in law school. The first question is, what is mooting in general? Well, essentially there is a need to refer to the definition of moot itself, which means that it is an issue that is up for a discussion. In other words, this means that if an issue of law is a moot point, then that issue can be considered as something that is not definite or unsettled, and both parties, either you are acting as the counsel for party A or party B, you can present your own arguments to support your standing on that issue. Other than that, mooting can also be understood as a court hearing, where there will be 2 parties, and usually it will take place based on an appeal, and there will be an appellant and a respondent for that purpose. Now, in participating in one, you will have to analyze the problem that is given to you. The problem can be based on the issues of the tort of law, contract law, a mixture of both of them, even criminal law, and so on. And most of the time, I feel that the particular law that will be involved would be something that is not yet settled in our legal system, or that it has undergone some recent changes with regards to its position in Malaysia. And moreover, a big aspect of mooting is that, of course, in presenting your arguments, you will first have to do the necessary research. For instance, if you are able to identify that the problem is on the breach of contract, then it is advisable for you to look into the landmark cases for breach of contract, any recent developments that you can find on it, as well as cases that are quite similar to the problem that you are dealing with. And once you are able to gather all these arguments all together, then it's time for you to prepare a written submission. in the written submission, there is no one format that fits all, as long as you are able to actually come up and to organize your arguments in a proper way, that one that is easily comprehensible and one that is well structured for the judges to read, then that should be okay. Therefore, in real-life mooting competitions, other than arguing on the day itself, which is the oral submission, you will also have to prepare a written submission to be submitted to the organizers in advance. And with regards to mooting, compared to popular belief, mooting is not the same as debate, although it does share the same elements to a certain extent, because you are needed to rebut the points that is raised by your opponent. The thing with mooting is that it involves one's skills in advocacy and the skill of persuading a person. I would say that in mooting, you are not directly arguing with your opponent, but what you are trying to do is to actually convince the panel of judges sitting before you that what your opponent is trying to say is not the correct position of law. And this leads me to the second question, which is, how is the flow of mooting? Is it the same with debate, where we need to counter all the points from the opponent's side? So, for the second question on this matter, actually, for the flow and setting of mooting, this is where the parties will be seated on the opposite sides of each other. There will be a judge in the middle, and there may also be a timekeeper or a clerk or a secretary to announce that we are now hearing the appeal of, for instance, the appeal between Ali and Amina. And the proceeding will usually start with the plaintiff or appellant to begin with their oral submission. There will usually be two counsels for each side, and thus the first counsel, who will be regarded as the senior counsel, will start off with their submission first. Imagine that in the problem, there are 4 grounds in total, and thus what you can do is that the senior counsel will deal with the first 2 grounds, and that the remaining grounds will be dealt with by the junior counsel. And grounds here is to be understood as the issues of law that arise in your moot problem. And so once the senior counsel for the appellant or plaintiff has submitted on the first 2 grounds, the judge will then order for the senior counsel of the defendant or the respondent to reply to the same 2 grounds. Hence, if there are 4 grounds in total, this does not mean that the first counsel of each side is needed to deal with all 4. The senior counsel can deal with the 2 first ground, and that the senior counsel from the other side would have to counter the set 2 grounds only. And after the senior counsel from the respondent or defendant side has replied to the arguments raised by the plaintiff or appellant, the plaintiff or appellant will now have to make a rebuttal, which is a counter to the arguments that was recently raised by the counsel for the respondent or defendant just now. For the rebuttal, this is where the counsel would raise several points, and it must be done in a short and concise manner. Hence, just because the respondent have said the name of a case wrongly, or that they have incorrectly cited the year of the case that they are relying on as an authority, you need to decide whether these matters are worth to be arguing or not, especially when they are matters that the respondent have said that are substantially incorrect, or that they have interpreted the law wrongly. Hence, you should carefully pick your points of rebuttals, and I would say that there is a need for you to pay attention at the time when the other party is submitting, so that you can identify any loophole or any weakness in their argument. So, in short, a rebuttal is like a final opportunity for you to strengthen your case and to prove to the judge that your client is in the right, and thus you have to make sure that it is properly summarized. And this is actually a matter of preference that I would usually do, but since a rebuttal should be short, I think that 3 points should be the maximum, and you should not argue more than that. Then when your time is up, the floor will then be passed to the other party, again the senior counsel, and they will rebut your points in the same manner, in which it will also be in a concise and short manner, and this is called as the surrebuttal. In that sense, the same explanation that I've said earlier will apply to Sir rebuttals as well. And once the Sir rebuttal has finished, this would mean that the first two grounds are finished, and we will then move to the oral submission by the junior counsel, in which the same flow will happen. Meaning to say that the junior counsel of the plaintiff will start, followed by the junior counsel from the defendant, then we will have a rebuttal followed by a Sir rebuttal. However, there are proceedings that will require the parties to first have their oral submissions, meaning that all the four grounds must first be dealt with, and once that is done, can they only proceed with the rebuttals and Sir rebuttals by each counsel. It is also important to note that during the entire proceeding, the judge will actually ask the counsel questions, so you must answer accordingly. And when the counsels are done with their respective submission, the court will take a short break, and then the judge will return to give their personal feedback to all the counsels, as well as the decision for the hearing as to whether the appeal is allowed or otherwise, or which party is to succeed with their arguments. And before I go to the next question, I would like to highlight that you are not encouraged to give a lecture on the position of the law during the oral submission, but instead you need to find a way to creatively persuade the judge to your argument, whether it is during your main submission or rebuttals. This is because you are not freely allowed to submit within your sweet time. In mooting, the parties are often fixed with a period of time. Usually for your main oral submission, this will be restricted to 15 to 20 minutes for each counsel. And that as for your rebuttals as well as for your Sir rebuttals, you are only with 3 to 5 minutes maximum to convince the court. Hello! So, in preparing your arguments, you must make sure to thoroughly read the facts of your case, and in doing so, you must determine what is the cause of action for your case. Would it be one that is existing in tort, contract, criminal, constitutional law, and so on? So that should be the first step before everything else. Then you may begin with your legal research, and I often find it very useful to read any textbook that would elaborate on such a topic. And then to broaden my understanding, I will look into any online articles where the authors would extensively explain the same. Reading articles, either ones that are published in legal journals or otherwise, are super helpful because they would usually give us the full outline of the area of law, like what is the landmark case for this matter, any recent developments, and they would also point us to the relevant statutes that we can invoke later on in our submission. And you can search this up by using Google Scholar. And on that note, you should also look into the relevant statutes as well as the existing case laws on this matter. So you can also utilize the legal database that we have, such as LexisNexis and CLJ. And do make sure that the authority that you are relying on is still good law, meaning to say that you need to double check whether that legal precedent has been overruled or that it still remains the same up until today. And if there is a loophole on that particular matter that you are trying to argue, in the sense that such a position has not been established in Malaysia, then you can look into other jurisdictions, especially those that are of Commonwealth countries, as it stands to be persuasive. But please be mindful of the cut-off dates, as not all the decisions from Commonwealth countries are considered as binding just because we are from Commonwealth countries. However, precedents that are after the cut-off dates can still be considered as persuasive if the other countries are more developed than us with respect to the areas that we are researching. Again, make sure to document everything in your records, and such as the number of the paragraph that you are relying on in the case and all the details, regardless as to whether you feel that those are irrelevant. And this would definitely help you later in doing a written submission, and because you want to check on some points relating to it. How many grounds do each of the counsel need to bring up, or does it depend on the moot question itself? So I believe that this was somehow answered earlier. Here it can be concluded that there is no fixed number of grounds that the counsel need to bring up. It depends on the moot question itself. Hence, if you are able to identify 2 grounds in total, then the senior counsel is to deal with 1 ground and the other is to deal with the remaining 1 ground. All in all, you must read and look into the moot question or situation carefully and identify what are the issues that are disputed between the parties. But remember, the grounds are not necessarily based on one subject matter only. It can be a combination of a lot of areas of law altogether. So the next question is, what are the salutations or the way to address the court? In a moot setting, since it would usually be an appeal court, so the right way to address the court would be, if the judge is female, it is appropriate for you to call her my lady, and for a male judge, this would be my lord. If it is during the preliminary round, there will usually be only 1 judge, so it is not really confusing to address them. But things will be confusing once you move forward to the next stage, and you will have to submit before the bench where there are 3 judges in total and they are made up of both genders. Hence, to be safe, I would use Yang Arif to address the judges, notwithstanding which gender that they are of. And next, with regards to salutations, if you are to address the court as a whole, for instance, if you are trying to refer them to the moot problem, you can say, with that, may I refer the court to the moot problem on page etc. etc. Or you can say, if the bench can move together with me to page 8 of the moot problem, page 8 of the moot problem. Hence, if you're trying to persuade the judges, you cannot do so without the proper decorum, and thus you must address them like, if this honorable court is to agree with the learned counsel's submission, this would mean that the appellant's right would be infringed as a result, which is not something that is to be encouraged in this court of law. So everything must be done with proper decorum. The next question is, if we don't know the question asked by judges, what do we need to do? Well, essentially, you should always try to answer questions from the judge as and when they are asked. Do not tell the judge that you will get to it later, because most of the time this will usually annoy the judge. However, there are circumstances undoubtedly that we will not be able to answer. Then the thing that you can say as a response is that, firstly, you can say like, my apologies, Yang Arif, I do not have the answer at the moment, but it is our submission that the respondent has indeed breached its duty against the appellant when they failed to adhere to the standard provided under the law when they should have in the first place. This is one way of saying that you don't know the answer, but in representing your client, this is your stance on the matter. Secondly, what you can do is to admit the fact that you don't know right away and say, Yang Arif, my apologies, I am unable to assist you on that point since I have not read the relevant authority. This should be okay. But there are judges who would not accept this kind of explanation from you, and be prepared for any follow-up questions on that matter. And my advice for you on this matter is that most of the time you already have the answer, but since you have been researching a lot, this fact might have slipped out. So do prepare a question and answer document where you put questions that you think that might be asked by the judges later on, together with the possible answers in advance. May it pleases the Honorable Court, I, Sarah Azahar, with my co-counsel, Nurul Iman Mansoor, am here today representing the appellant, Margaret Dawn. On the other side, representing the respondent, Dr. Townsend, are Nur Fatiha Azahari as the senior counsel and Muhammad Taufik Sufyan as the co-counsel. Yang Arif, as of today, the appellant's submission will consist of 3 grounds. Firstly, the respondent is liable for the brain damage suffered by baby Marilyn. Secondly, the respondent had breached his standard of care during the management of delivery. And finally, the appellant is entitled to be compensated for the damage of nervous shock. I, will present the first two grounds, whereas my co-counsel will present the latter. We request that this honorable court lend us 20 minutes each for our submission and 5 minutes for rebuttals. Ya Arif, before I begin my submission, does the court require the brief facts of our case? Here, if the court say yes, then you'll say much obliged, Ya Arif, and proceed with the statement of facts. If you're the senior counsel and you're ending your submission, you can say, if I can be of no further assistance to this honorable court, I shall yield the floor to my co-counsel to proceed with the appellant's remaining submission. With that, I thank the court for its time and indulgence. You can also put an opening statement before introducing your grounds. For instance, the third ground just now is in relation to nervous shock. So I'll just show you an example if you're acting as the junior counsel together with an opening statement. So this would be the example. If it pleases the honorable court, I am Sarah Azahar, appearing as the co-counsel on behalf of the appellant, Margaret Dawn, and I will deal with the third ground as of today. Ya Arif, it should be noted that, like any other mother, especially upon the experience of their firstborn, will be very particular on every single detail of their baby, as at that moment, every impact or anything resulting from it would be significant. As in our case, right after the delivery, and as mentioned earlier by my co-counsel, it has been affirmed that baby Marilyn is now suffering from brain damage. Not only that, the baby is also attached with consequential developmental deficiencies, which will lead her to become paralyzed and vegetated. In other words, as good as dead. Undoubtedly, this particular event that has occurred is the morbid one, and as a result, our client, the mother of the baby, has suffered from nervous shock. Thus, in my submission today, I will seek to convince this honorable court that our client is entitled to be compensated for the damage of nervous shock. I will now proceed with the submission. So that is an example if you're like the co-counsel and you'll have an opening statement together. So the last question is, what are the challenges in online mooting and how is it different from physical moot? Well, the challenges in online mooting is that I had to pay more attention in reading the judge's body language, because if it is a physical moot, their body language can actually be used as an indication as to whether what I'm saying is whether it is in line with what they want to hear once they ask me a question. Since it is harder to read the judge's body language, this makes me even more nervous, anxious when speaking, especially when it is harder to maintain eye contact. Like, you wouldn't know where to look. Like, should you look at the camera directly or should you look at the judges instead? Also, it sucks if you're at the moment trying to submit a crucial point, but then you lose your internet connection. And when we were participating in FDI last year, it was my first virtual moot, and we had to actually make an arrangement with the faculty as well as UITM so that the team and I could stay on campus during the competition to ensure that our internet connection would be okay during the entire time. And at one point, I remember that we were facing a team from China, and that in every 10 minutes of their submission, they would lose their internet connection, which is such a shame because everyone has been preparing for that day for like the past 9 months or so. So I think that would be the main challenges that I can say for online mooting, but I would say that it is not substantially different from a physical moot. But it cannot be denied that a physical moot is more exciting because you get to see your opponents directly, you can talk to them before and after the session, you get to be at the venue and you can visit other law schools. But yes, since it is a physical moot, it can be more intimidating. Like, you're so close to the judge, like you can feel them judging you, like literally judging you. But since we are now like in the pandemic, I can say that I love physical as well as online moot equally.